Good morning, everyone, and welcome again to today's Heavy Vehicle National Law Webinar Series Part 2. In today's session, we will hear from two of Australia's most experienced chain of responsibility experts in Paul Endicott and John Macris. Paul and John will discuss executive officer due diligence and executive officer liabilities under the Heavy Vehicle National Law and how you may discharge some of those obligations. The session will go for approximately 1 hour with questions at the end of the presentation. If you would like to ask a question, please do so in the question and answer tab at the bottom of your screen. We will attempt to answer as many questions as possible at the end. Over to Paul and John.
Okay. Well, first up, I think on behalf of John, Zenergy and Kingston Reid, I'd like to offer an apology insofar as the IT issues we had last week. And moving forward, hopefully you'll enjoy and find the session we have for you today most interesting. It's an area that is largely misunderstood, and we'll be talking about that in detail in terms of what you need to do at a various level in your own business relating to the transport activities. So I'll pass over to John to have a bit of a chat about the overall presentation that we've got for you today.
Thanks, Paul, and good morning, everyone. Yeah, I agree with share Paul's sentiments. Hopefully we'll get through this session and there'll be ample time for you to ask some questions. Part of Paul's comment about why the law is misunderstood is there's really not a lot of legislative or court guidance in this area. It's a really interesting area in that we've had due diligence, for example, in other jurisdictions since 2012. Then the Rail Safety Act came in, and now we've got the Heavy Vehicle National Law. But there's not a lot of case law in the area, and so what we're left to do is pick up bits and pieces of what the courts have said, and we'll go through some of those today when we talk about who's an executive officer. But certainly the principles around why is an executive officer liable are pretty clear. They've made that really clear, and it's really, if we go to the nub of it, it's really about saying, you know, these people are decision makers within their organisation, and the decisions they can and should make relate to having proper systems in place to make sure that the transport activities of your organisation are safe. And we're starting to see now cases trickle through in the Heavy Vehicle National Law. So we've had the first prosecution in Queensland earlier this year. There was a conviction they were fatigue breaches, and they didn't bring it under the fatigue provisions, the prescriptive provisions. They brought it under the primary duty, and there was a conviction there. We've got a case in Victoria going through the courts at the moment where they're going after the business and the director, so it'll be probably our first officer case. And the New South Wales regulator told me not long ago that they're currently investigating a similar case in New South Wales, which should be then the first of the prosecutions against a corporate and an officer, and that will be a director's one as well. So the regulators are actively working in this area, and so this is a really timely reminder about you know, what we need to do and what are the requirements. So for the purpose of today, this is the agenda. I'm going to ask Paul to do a bit of recap on what the primary duty is, because we really need to understand what that requires to then look at what's required of an executive. We'll look at then who is an executive and some of the definitions around that. And as I said, not a lot of case law in the area, but we can pick up snippets of what that means. Look at due diligence, and fortunately it's prescribed for us. So that gives us some really good guidance on what that means. And then we really wanted to focus on what are the practical things that we can do to meet those obligations. So we'll spend some time talking about those practical things, and I'll impose on Paul, who has a regulator background, you know, what are some of the things he would look like if he was wearing his regulator hat. And of course, we're proposing to leave lots of time for questions. So I'll hand over to Paul to do a bit of a recap.
Thanks very much, John. And something that I might just mention before I move into this particular area of the key principles of the HVNL in relation to the primary safety duties is we've got some matters before the court in Victoria where the Victorian Police Heavy Vehicle Unit and Homicide Squad have actually laid charges against the manager of a business in regards to 4 deaths. And they've laid those charges under the Victorian criminal legislation. or Crimes Act in terms of manslaughter. So we're seeing the criminal side of things stretching a little bit further now, and there has been a number of other ones. There's been some in South Australia, previous one in Victoria, and of course this new one that relates to 4 deaths caused by a heavy vehicle driver leaving the roadway at the scene of a motor vehicle stop. And I'm sure you're probably aware of what I'm talking about. So the key principles behind the primary safety duties, the principle that applies to the duties of executive officers and parties under the HVNL is the first one to remember is that duties are not transferable. So for executives that are sitting there that appoint someone in their business to manage these responsibilities, clearly it has no effect. So if someone in the business is being given the responsibilities to manage the requirements of the HVNL in terms of executive officer liability, then it is not transferable. In other words, it has nil effect on the operations of this particular law. Persons may have more than one duty, so you may have multiple people within your own business and equally that of other businesses that have and share the same duty as you do. So it's about finding out through discussions, perhaps compliance assurance conditions that are in place, contractual arrangements. So this is very important in terms of onboarding people and of course monitoring and reporting. But we'll talk about that a little bit further as we go through, not to sort of stall on this area too much. Now, more than one person can have the same duty. So this walks hand in hand. So the duties are not transferable. Persons may have more than one duty and more than one person can have the same duty. Okay, so I'd imagine there'll be some questions that fly around in that one in regards to how your business manages, or even yourself, how you manage these duties, given what I've just said.
And I think what's really important, you probably hear me say this a couple of times today, you've got to be really clear about where do you fit in the chain, right? So if you're arranging trucks to come in to pick up things from your workplace, then you're a consignor. If you're loading it, you're a loader. If you've got people who are managing the loading process, they're a loading manager. So the starting point to all of this is working out where do you fit in that chain.
Yeah.
And for most businesses, you'll have a fair idea, but you need to look at the extent of that duty, and we're not covering that today. Paul's going to do a recap, but where do you fit in? And that will drive what you have to do to actually meet the obligations, and therefore what the executive officers need to look at.
So just as far as a recap's concerned, in relation to the primary safety duty, is on the left-hand side, each party in the chain of responsibility must ensure, so far as reasonably practicable, the safety of the party's transport activities. And transport activities include, over on the right, the business practices of your particular organisation or business, the making of decisions associated with the use of a heavy vehicle on a road. And business practices can be mean practices in running the business associated with the use of a heavy vehicle, including, for example, your transport activities, about the decisions you make in a nutshell in relation to the use of heavy vehicles, risk assessments, and the controls for removing or minimising the public risks. So this is about risks to the public when you're operating your vehicle out on a road. So other motorists and pedestrians. Road users is probably more the case, or people that may not necessarily be a road user, but are associated with a road or other place. Operating policies and procedures that you have designed to manage your particular business. Human resources and contract management, which is very important, and how that fits into your business and is associated with your supply chain. Compliance assurance conditions, equipment monitoring, and reporting. So this is non-exhaustive, this particular list, and I say that you need to have a very good understanding of what your business practices are. The key point in this is the reasonably practicable. What is reasonably practicable in terms of what you know, or reasonably should know, given the size of your transport operations, and of course how you can control and influence those safer outcomes.
And you recall from the first series where we spoke about the primary duty itself. When we talk about reasonably practicable, it's really a risk management exercise, right? Again, goes back to what I was saying, where do you fit in the chain and what are the risks and what are the measures we need to put in place? I think when Paul talks about things like transport activities and business practices, we've got to be mindful, just like the safety laws and the rail safety laws, this stuff is beneficial legislation. So the way it's interpreted by the regulators and the courts really comes down to what the law's about. And I think Paul touched on this when he was saying it's about public safety. And Paul reminded me about this after the last session. We were talking, the objects, what are the objects? And I went back and had another look. And when you look at the objects of the legislation, it's about public safety. It's about the impact on the environment, the road infrastructure and public amenities. It's about promoting productivity. So I had a case where we were overloading our trucks. And the court looked at it and said, well, hold on, you're not promoting efficiency and competition because you're getting a benefit because you've got overloaded trucks. And part of the fine reflected the fact that we were getting a benefit out of our practice, our business practices, that we shouldn't have got. And of course, the fourth object is about road safety. So that's the lens in which the legislation is looked at and the lens in which Paul has talked about transport activities and business practices.
Okay, so moving on in terms of our primary duty, without limiting the primary duty, each party in the chain of responsibility must, so far as reasonably practicable, A, eliminate public risk, and where the eliminate the public risk, and we're not reasonably practicable to eliminate, minimise those public risks, and B, ensure the party's conduct does not directly or indirectly cause or encourage the driver to contravene the HVNL, the driver to exceed a speed limit. And I think this is where I got to last week, where we started to stumble in terms of our IT issues. The third one there is another person to contravene the law. Before I go on a little bit, I want to have a talk about B2, if I can, under the Act, and this be the primary safety duty, pretty much word perfect for the primary safety duty. I think it's 26C of the Act. So, and in terms of the driver to exceed a speed limit, there's only probably three other areas, and don't take this as legal advice, but I think there's only three other areas where speeding is mentioned in the some 780 sections within this law, and even within the instruments that are designed under it or enforced under it, be the regulations. There is only probably three areas that speeding's mentioned, and the other relate to vehicle standards and the tampering with speed limiters that are fitted to vehicles. And that comes out of probably the large speeding campaigns that were conducted by New South Wales Police and Roads and Maritime a number of years ago, and I can talk firsthand to those. So a driver to exceed a speed limit. So this is whether your act or omissions cause the driver to exceed a speed limit. These are about your business practices that have a direct impact on the driver speeding. So it's asking here to have very safe and very defined areas within your particular business practices to eliminate speeding. And it's very important to note that the law is quite unforgiving in terms of this, because we all understand that speeding is dangerous. Speeding kills, is one of the largest killers or the main cause of death and serious injury upon our road networks. And of course, herein it's identified as a great risk. So it's calling for risk assessments to be, overarchingly, it's causing for risk assessments to be undertaken, and in particular, to assure that a driver of a heavy vehicle doesn't break any part of the law, and it calls out more specifically speeding. And it doesn't identify speeding, what type of speeding. Is it, speeding at 60 kilometres an hour or at 100, where vehicles are mechanically or electronically limited? No, it's talking about a speed limit that applies to a driver at any time whilst driving a heavy vehicle. So it doesn't get much clearer than that. And of course, conduct includes, for example, asking, directing, or requiring another person to do or not do something. Something, okay? Anything. It's something. So asking someone to do something or not to do something. Entering into a contract with another person to do or not do something, or entering into a contract that purports to annul, exclude, restrict, or otherwise change the effect of the heavy vehicle national law. So the primary duty is to ensure that you're not working to exclude the operation of the heavy vehicle national law. And what it does is it creates an offence further on that John's going to speak to if you do undertake in these activities.
And just be mindful when we talk about conduct. I'm seeing now in investigations, the regulators are asking for, sure, your emails and your contracts about what was the dialogue between you and the driver or you and the transport company. But also they're asking for other things like text messages and, notes of conversations. In my particular case that I'm thinking of, we were a consignor. The transport company business owner was asked to do certain things which on one view were contrary to the law, which induced speeding in this case. And he kept diary notes of the conversations, which included things like, I'll just get him up and I'll give him some more money. And the transport company kept those records. And of course, they all form part of the conduct of my client, who is a party in the chain. And then we were being asked questions about, well, who's making decisions around this stuff, which really gets us into executive officers and who's making decisions for the organisation about the systems it adopts.
Okay, I think the question is, before we move into responsibilities and duties and things like that, is who is an executive? So an executive means, for a corporation, an executive officer. That doesn't help us very much.
No.
An unincorporated partnership, a partner in the partnership, still probably getting a little bit clearer. An unincorporated body, a management member of the body. So probably a little bit clearer there in its definition. But it also means, as you can see in the lower commentary, an executive officer of a corporation means a director. Okay, that's pretty simple, the director of the corporation. But it also includes any person by whatever name called. In other words, any person, doesn't matter what they're called, can be called a manager, a logistics manager, some other name other than perhaps director, and whether or not the person is a director of the corporation, so they may not be a director of the corporation, who is concerned or takes part in the management of the corporation. So a director, sure, but any person by whatever name called who is concerned or takes part in the management of the corporation. Now, what we need to do is take this apart a little bit further to see what, I suppose, stacks up to be concerned or takes part in the management of the corporation. And I'm going to ask John to pull that to pieces because it's more a legal question than an operational question. So who is concerned or takes part in the management of the corporation? So who, whatever, it doesn't matter what they're called, takes part in the management of the corporation.
Yeah, thank you, Paul. And look, just that definition raises some really interesting issues. So let's take the third bit, which is an executive for an unincorporated body. What's an unincorporated body? Now, most infrastructure projects we have going around, for example, in New South Wales, are all joint ventures. And they're all run by a leadership team or alliance management team. Does that mean that those people are management members of the body? because it's an unincorporated body, that's probably right. And this hasn't been tested yet, but I see it, we've had a couple of cases in that space where ordinarily we'd go back to look at the individual JV partners and say, well, who are their officers within those organisations? And that's what you do in the safety context, because it talks about the officer of a corporation. In this context, they've widened it to say if you've got a partnership, it's one of the partners. If you've got an unincorporated body, it could be a management member of the body. So just watch those unusual arrangements like JVs and hybrid type arrangements, because this does widen that particular definition of an officer. But going to Paul's question, who's a person who's concerned or takes part in the management of the corporation, is a question that often lawyers get asked. And people will often give me a list of names and say, John, here's 20 people. Tell me who's concerned or takes part in the management of the corporation. Or in the safety context, they say, John, the definition is actually from the Corporations Act, which says a person who makes or participates in making decisions that affect the whole or a substantial part of the corporation. Now, whether there's a difference between those two phrases, my guess will be probably not. It hasn't been tested yet. But here's a list of 20 names. Who are they? And to give you a technical legal answer, I've got to understand what their role is and what decisions they make or participate in relation to the organisation. So there's a little bit of guidance in some really old cases. And one of the oldest cases is the Gretley mining decision, which was back in 2004 in the safety context. And that was because the older OHS Act didn't have the current definition. They had this definition, which was concerned in or takes part in the management of the corporation. And that was a mines case where we had a collapse. They drilled through a shaft because they had some mine maps that said there was no water behind there. They drilled through, it was full of water, rushed through and drowned and killed a number of people. And they prosecuted the company, of course, the mine managers and the under manager, the surveyors and some of the other managers. And then they had to go through this exercise to say, were they an executive in the context of that particular legislation? And out of that case came some principles, which have then flowed into other cases that said, as Paul said, it doesn't matter what you're called, it depends on what you do, is the starting point.
That's right.
The second bit is that the person's decision-making role or authority has to go beyond merely carrying out someone else's decision. So employees carry out decisions, senior management executive make the decisions or participate in the decisions. And that's really the defining line. But that decision that they actually participate in has to affect a big part of the corporation. Now, what's a big or substantial part of the corporation? Again, there's a little bit of guidance on that, what's substantial. It doesn't have to be only, for example, a transport manager relating to a transport activity. That decision can be wider than that. And I'll give you an example. If we go back to the only case we have in the work health and safety context, which was the ACT decision, which you all know about, where there was a guy who delivered some spoil or soil to a construction site, and he was told to put it over there somewhere, and there was a power line that was hidden, and he was electrocuted when he raised the back of the truck to dump the load. And the site manager, who was also an engineer, was prosecuted as an officer. And then so the court had to go and look at all of his decision making. And in that, they actually found he wasn't an officer because he didn't make, they looked at the number of projects, the types of work that the business did, what was the management structure. And in that, they said, look, he didn't hire and fire. He didn't really have purchasing authority. He did make decisions about contracts. And whilst he went to management team meetings, he really was there as an observer, might have given some input, but really didn't make decisions. What was interesting, so he was found not to be an officer, but what was interesting in that case was the court said, interesting, there was no evidence raised by the prosecutor about certain other things, like directions over which contracts they'd take, direction over who set up the corporate structure, who set up the policies, who decided which projects the business would enter into. There was no information around that. So I think this guy was partly lucky because the prosecutor didn't do their job properly. And whilst the guidance is a little bit all over the place, I think you've got to form a view that we know directors are in because the definition says directors are in, right? And they're directors because they're named directors in ASIC. I think you've got to form a view that from a general point of view, your key decision maker, your executive, your leaders, people who report into the CEO, all those senior leaders need to think of themselves as officers. And I often say this to people, I can't tell you who an officer is in every case because I need to know what decisions they're involved in and participate. They don't have to make decisions, they just have to participate in substantial decisions. But I think people around that table who are talking about things and reporting to CEOs in those positions, I think they need to act as if they are officers, and then look at the due diligence requirements and say, can I personally meet those? Because as I said, I think at the beginning, due diligence is not about what the person does, but about their ability to help shape the organisation's safety transport processes and systems. So it's a very grey answer I've given you, but it's really, it is that grey. When you look at the case law, I've actually got a case here, which is a really nice summary of the due diligence requirements in the work health and safety context. And even that says the area of due diligence hasn't been settled. There's a lot more law that needs to come because we've only had one real case in the safety context, and every other case has been a director, and directors are easy because they're named as officers. So it's about, are you involved in the decision making within your organisation, not just for heavy vehicles in this case, but it could be financial decisions, it could be HR decisions, it could be safety decisions. If you participate as a group in those, you need to think of yourself as an officer.
So just to recap in terms of how do we find out in these things, just very simply, our risk assessments, following risk assessments that need to be carried out is perhaps an accountabilities matrix, but in that too, roles and responsibilities. So a duties, obligations type audit or assessment of the business, risk assessment, audit of the business in terms of who does what, and their role and responsibilities. So the three things there can cover off very quickly if they're done properly in helping you identify where you need to provide training, where you need to provide support, and those things be managed within your business. Of course, this then helps with reporting to the executive that in fact need to be able to show that they're exercising due diligence. So that's an operational solution. It goes further. And you might say, well, Paul, that's really easy. It's not that easy. No, it's not. So there needs to be some assistance that's provided. We'll talk about this more as we go through, but they're the very basics in terms of perhaps what needs to be done to start getting the business in better shape, or making sure the business is in shape for what it has at the moment. So we'll continue.
Yeah, and look, Paul raises a really good point, because I had this question just yesterday in the safety context from a government department, which is a statutory corporation, and the officer provisions around Crown or government is slightly different, but this was a statutory corporation, and they said to me, John, where in the law do I work out where the roles and responsibilities are for different people in the organisation? Yeah. And the law doesn't define that. It says each business is different, so we're just going to give you a set of framework to work with. You need to look at your own organisation and work out where those lines of authority are, where the delegations are, where the responsibilities are. So as Paul says, that's not an easy step to take, but it's one that needs to be well thought out. But I think if we go into, I always say this to people, the who's an officer can be a grey area. I think if we have people who are participating in decisions or are concerned about whether they're officers, I think we need to look at the due diligence part of the equation and say, look, you may well be, and therefore, are we doing the things we need to do? So the way the due diligence provision works is it says, just like in the work health and safety space and the rail safety space, it says every executive officer must exercise due diligence to ensure that the business complies with its HVNL obligation. That's what it's saying. So this is what we call a positive, proactive duty. The old safety laws used to say when the company breaks the law, the officers have broken the law. This provision says, no, at all times, you have to exercise due diligence, which is a positive obligation. And it doesn't matter whether the regulator investigates the business and prosecutes it or not. It's a standalone obligation, and therefore we've got to be mindful about, what does due diligence actually mean? And certainly, what can it look like is the question is the next question, what does it look like? And there are certain elements that the regulator and the courts are looking for in terms of, what due diligence look like. And so Paul mentioned this, people got to know what this is all about. You've got to know where you fit in and know what we have to do in terms of decision making. So understand what's out there. What resources do we need to apply to these activities in our business, right? What information do we need to have a look at and give to other people? What checks do we need to do? And I've added verification in there because the last element of due diligence talks about executive officer's personal verification about what's going on. What we're going to do now is we're going to go through each of the 5 provisions of due diligence that are set out in the legislation. And as I said, we are guided somewhat because they kind of set out what they're looking for. Now, when we look at that formula in 26D, it is, right, which kind of mirrors the work health and safety one, although it's just framed slightly differently. It says you've got to take reasonable steps to do these things, right? It's not saying this is the exhaustive list. It's saying these are the minimum things we want to see. Your organisation may have other things in place that can add to the steps that we're already talking about. So don't think of these as a minimum. Think of these as steps that we need to take as at bare minimum, and we have to do other things. And all of this, remember, as we said in our first webinar, this is made to complement your safety management system, right? And build this stuff into your existing frameworks that you have for your safety management system. Because arguably, if you're doing it in the safety framework, there's not a lot of tweaking to do to include the heavy vehicle stuff as well, once you know where you fit in the process. So let's take each of the due diligence steps one by one, right? The first one, as you know, is to acquire and keep up-to-date knowledge of the safe conduct of your transport activities and the associated risks. So what do we do? Where do we fit in the chain, right? And therefore, what do we have to do? So if I'm not a transport company, but I arrange trucks, what are the risks for me? Well, a truck comes in, it may have a load, it may come in empty, right? What do I need to know about that? Do I have the right contract? Do I have a contract with the right company? Do I have the right set of contracts with these people? How do I influence what goes on in the trucks there? Loading times, the checks that we do, all those kinds of things. So keeping up to date is broadly about what's going on in your business, but what's going on generally in the industry. So are you getting information from the industry generally? Are you part of a trade association? Do you get, the National Transport Commission publications, right? Where do we fit in? What are the things we have to do whilst that heavy vehicle is within our purvey? And also, how do we influence what happens after it leaves? So if we've delayed the truck at our site, what does that mean for the rest of the journey, the planned journey that we've got? Do we need to do something? Do we need to call someone and communicate, right? And say, there's been a delay on our end, you need to factor that into your brakes, ring the end customer if you've got an end customer where it's going, and say, look, this has happened at this end, just so you need to know some other things that need to happen. So how are you keeping up to date with the law, what the law requires? Things like training, like today is a training session. What training are you giving your team about their roles and responsibilities, about what's going on in develops in the space? What are you subscribing to the heavy vehicle regulator website to look at updates? They've got some really good updates there. They've got lists of cases that have been through the courts. Are we seeing what's going on? Just keeping up to date and getting that regular flow of information about what's going on both within your business but also in the industry generally is really important. That's the first one.
Okay, the second one, B, to gain an understanding of the nature of the transport activities and the hazards and risks, including public risks associated with those activities. For example, seek advice from qualified persons to gain a greater understanding of the transport hazards and the risks. So have someone that has extensive experience in the transport industry in identifying transport activities or working with transport activities to understand the hazards and risks and seek and act on the advice at the earliest stages. So what you are doing here by this particular slide is complying with the primary safety duty to understand the risks and therefore eliminate those risks. And if you can't eliminate them, minimise them. So that's what this particular slide is talking about. Identifying the risks, seek an understanding of those transport activities and the hazards and risks that are associated with it. So what you're doing here is, as I said, signing off on the primary safety duty, or one part of it anyway.
Yeah, really important. And a common question that someone will probably ask that we get is simply, I've got a transport manager or a safety manager who looks after this in our business. Does that relieve me of my responsibilities, right? As Paul said earlier, the first slide, you can't delegate your responsibility. If you're an officer, and therefore you've got to meet these obligations. Part of meeting that obligation of understanding the nature is to have qualified people within your business look at those activities, but you want to be getting feedback from them, reporting from them, asking questions about, we've got risks, right? How do we deal with things like loading, dimension, speed, restraint, fatigue, maintenance, if that's part of your obligation? How do we deal with those things in our business? And what information are you seeking to know what those risks are? That leads directly into the third element, right? So we've got a third element, which is, you know what your risks are, which is the second element. What processes and resources have we got to deal with the risks? So we know what they are. We actually have to, we know this is a risk-based law. So that means we've got to eliminate, as Paul said earlier, or minimise. So what processes have we got? And so your resources could be your internal people. Get engaging experts like Paul to come out and give you an assessment of your activities, subscriptions that you've got for new services, budgets that you allocate to transport and safety activities. They're all of your resources. Your processes are going to be, as Paul said, what's your safety management framework for heavy vehicles and how does that fit into your safety management system? What checks, balances do we have? What advice are we seeking? What reporting are you getting? That's how you think about your resources and processes in terms of dealing with the risks that you've identified.
And that talks to also, the resources. What are the required resources to achieve that particular level of safety? So in looking at the next slide, D, to ensure that the legal entity has and implements processes to eliminate or minimise transport activity hazards and risks, and for receiving, considering and responding in a timely way to information about those hazards, risks and incidents. So this is now talking about ongoing, have an incident reporting and escalation process within your business. Now this doesn't have to be reinvent the wheel. And you'll find that a lot of businesses, if you were to say to them, we need another process here or another system, we're on the 11th floor here and I don't grow wings, don't have the ability to grow wings very quickly. Of course, I'm going to need them if I suggest to a business that you need another system. It's crazy. These things can be incorporated to, hopefully, your existing safety framework. It doesn't have to be reinvent the wheel, but what you do need to have is quite a robust safety management system in place to enable that. Ensure processes are used to monitor existing hazards and risks. This is about the use of resources to ensure that your compliance levels are at an acceptable level that you understand and are clearly briefed in and are aware of. And of course, have processes to implement corrective actions, which is most important. So it's okay to own perhaps a weighbridge on your site and have trucks repeatedly leaving over that weighbridge in breach of their allowable mass limits. Your fatigue management system or speeding management system that hopefully monitors your vehicles in real time, which is the industry standard at the moment, and there'd be hundreds of speeding events, not only over 100, but over any posted speed limit. And of course, then sending a letter out to whoever the operator might be, if it's not your own vehicles, and but may have your goods that have been consigned for transport, and equally you may be scheduling that vehicle at its pickup and destination. So not doing anything about those events, or closing my eyes and expecting it to be the operator that has to manage all these things. So, some really good messaging in this sort of stuff that you need to be able to be aware of as an executive, being identified as having a responsibility.
Yeah, and look, there are many cases that we're involved in that involve, a risk that's known, for what we call a known and foreseeable risk. You've got the data's all there. The regulator will get access to this data, right? So, and that's how I met Paul during an investigation where he asked me as a regulator to produce a whole heap of data, which clearly identified that we had problems but hadn't closed them out in a timely way. And your own records will do that. And so I often say to people, you knew there was an issue. Who was looking at the materials? Who was reporting up the line so someone could make a decision about we need to rectify that process? And that's what really this is about. This one's really about saying, how are we identifying the risks before they become big problems, and how are we closing those issues out? Because we get into this last area, which you'll be familiar with from a safety point of view. This is a personal obligation on an executive officer to verify that the processes we just spoke about are actually happening and being implemented. So that's a personal verification. So how do you it's not saying, oh yeah, look, Paul's my transport manager, he said it's okay. How do you personally verify? It might be part of the okay that Paul says it's okay, but you want to be seeing some reporting. You want to be seeing some trend analysis. You want to be seeing some results from internal and external audits. You want to know that people are getting training and information about the heavy vehicle national law and how it works. This needs to be built into your reporting, just like it is in your safety reporting. And again, it's about having a framework that really sits along your safety framework, and you incorporate these elements into the relevant bit.
So showing robust leadership. This is about being quite clear in what the expectations are. But I think from this, in terms of those risk assessments that we spoke about, and then understanding or having an accountabilities matrix with those key areas of responsibility, providing training, then that ensures that the people that you've identified as holding those particular prescriptive positions that are trained adequately enough to be able to execute their duties in terms of managing this particular law. Effective accountability processes, as John said, maintain a positive transport safe culture, which is extremely important. Setting an effective CLR policy that's not overarchingly quite convoluted, but has pointed and clear instructions in terms of how the business, not going to a procedure, but being a policy that shows that the business is committed to transport safety and eliminating the risks as best as it can reasonably practicable affect those changes. Ensuring competent staff, and that goes back to training, and providing sufficient resource allocation.
And you'll find all of that really aligns with the risk management standards,
yes,
your local 4801 or your 45001, the ISO. And when you look at those standards, it actually, in fact, I've got an extract here, and it actually says, success factors, right? And the first success factor in having a robust system is top management, leadership, commitment, accountability, responsibilities. The stuff we've been talking about. Top management leading, developing, and promoting a culture. So this is really why there is executive liability in these regulatory laws, because it is very clear, and as you know, leadership starts from the top. And if the top drives it, it'll happen with the inclusion of other people. So we thought we'd use this as a bit of a summary to say, what are we really looking for in terms of due diligence? Because when we get into pear-shaped, as I said, there's a couple of cases going through the law at the moment. This is the fines at the moment, as you well know from your safety laws. You see the numbers are slightly tweaked because in New South Wales now, we're getting fines that are being indexed every year, like they're doing in Victoria. So rather than say the fine's 300 grand, it's going to be 300 penalty units, and then they're going to tweak the penalty unit. So when we talk about the fines, I mean, the category 2, I've just finished the case. We were a consignor. We were charged under the old provisions pre-2018. Fortunately, there were no executive officer prosecutions. The maximum fine for the consignment, each breach, was $53,000 at that time, a year ago. We're now talking about a maximum fine of $1.6 million. So the stakes have gone up, and certainly we're seeing category 1 cases in safety offences. We've had the first industrial manslaughter case in Queensland, and some reckless prosecutions in Victoria and Queensland for directors. So certainly the safety regulators are laying out what could happen, and we'll certainly start to see some of the cases will trickle through in the heavy vehicle space as well.
Just recently, in terms of sanctions as well, John, we've seen a number of enforceable undertakings, and in that too, we've been, seen improvement notices being issued to by safe work investigators in New South Wales, not heavy vehicle chain of responsibility investigators. So it's two-handed, isn't it?
Yeah, and look, the most recent Victorian case on a heavy vehicle was actually a safety case, not a heavy vehicle case. It was a trucking business, sweeper trucks, failing to maintain the truck properly. there's an incident, someone dies because of the truck didn't stop properly. That was actually brought in under the work of the OHS Act in Victoria, and $300 and something thousand fine, and the director was prosecuted as well. And as Paul mentioned, I think it's the next slide anyway, the police can step in and look at these cases from a manslaughter point of view, and we've got examples of that, and I'll talk about that in a minute. But Paul raised enforceable undertakings. They were introduced in the Heavy Vehicle National Law in 2018.
That's right.
We've been doing those in the safety space for quite a while. I can tell you they're not easy to undertake. In the safety space, particularly in New South Wales and Victoria, the hoops that you now have to jump through to get an enforceable undertaking over the line almost sometimes make it not worth trying. I think we've got one now in New South Wales under the enforceable undertakings. If you look at that one, the bulk of that one is training elements, right? In the safety space, they talk about beyond compliance. You probably wouldn't get away with a whole undertaking with training type activities because it's got to be beyond compliance. So I think you'll find the heavy vehicle regulators will also start getting mature in how they view undertakings and what they ask from them. But the other thing I wanted to raise in this slide was the prohibition order. So if you're I've had a case where a director received a prohibition order that said he couldn't be a director in looking after the business, which was essentially a transport business, for 12 months because of his conduct in not meeting his due diligence. And in fact, he did nothing. And that was due to health reasons particularly. But he was, we actually agreed to it because we knew the court was going to do it, and it could have been a whole lot worse. So we actually got instructions to put the prohibition order, negotiate the content of that order beforehand. But that can apply to any role within there. It could be a transport manager. You could be prohibited from being a transport manager.
Case studies that were used by myself at the National Transport Commission in Melbourne, providing advice to the participating jurisdiction ministers on what changes needed to occur to the Heavy Vehicle National Law. And in regards to these prohibition orders, the case study of the Lennon's triple fatality at Menangle, where 3 members of the Logan family were killed in one accident, or crash, I should say, wasn't an accident. And the driver, Vincent George, being convicted under criminal legislation in terms of 3 counts of manslaughter. There was no ability to take those vehicles from the road other than to drag them off for further inspections. There was no long-term, let's see what the problem is here, to see if we can get this company up, right, or out, one of the two. And there was no provisions within the Heavy Vehicle National Law, similar to the tanker explosion at Mona Vale that we had to manage at the time. And no prohibition orders could be put into effect to prevent these operators from continuing about their business on a daily basis without having some capture of the, I suppose, the risks that were being posed to the travelling public, the people of New South Wales. So there was sort of, only registration type provisions available to take these vehicles from the road to ensure that there was no further risk. So these are the case studies that we use to build these provisions into the law now, which are, and enforceable undertakings that were, which are quite useful to regulators in terms of who's exposing the people of New South Wales to unacceptable levels of risk.
Yeah, so what you're seeing in more serious cases, like the ones that Paul's referred to, which are very serious cases, there'll be a fine or something imposed by the court plus an additional order. So it's not just one or the other. You will actually see a combination of things being used, and these equally apply to executive officers as they do to the actual organisation itself. This is the example that Paul referred to very early and I referred to just recently. This is a real case in 2017 where a director of a transport company was charged with manslaughter and found guilty of manslaughter. And in that case, it was actually a maintenance issue in South Australia. There was a brake issue on the truck. A number of drivers had taken the truck out, come back and said, "Hey boss, the brakes aren't working properly." Just before this particular incident, there was a brake fade, and the driver came back and said to the boss, "Hey, the brakes aren't working properly." Rather than get them checked out properly, he had his his internal guy quickly have a look at the brakes, said they were okay. On the last occasion, the brakes failed. The truck was heading towards a car with people in it. He swerves, hits a power pole, and unfortunately, he's killed in that accident. And the police went in and looked at that, as did the safety regulator. And the police said, once they started doing their investigations, looking at the maintenance of the truck, looking at speed limits, looking at the works, there was a discussion between the police and the regulator, and it was determined that the police would run this one as a manslaughter case. He was jailed for 12 years and 6 months. He then appealed to a higher court. A higher court looked at it and said, no, that result's right. We're not going to change that decision. So that's a live example of, we're talking about public safety here, and that public safety element brings in the police, and in some jurisdictions like South Australia, the police are the heavy vehicle regulator anyway. So, there's a lot of things that can go wrong in these. We're just conscious of the time, and we thought we'd better open up to some questions, and we'll let Owen run that question phase for us.
You there, on?
I certainly am, and we do have a couple of questions that have come through. So first question is, under who is an executive? I think they're referring to the slide.
Yep.
If you're a part of a committee which seeks to set or sets policy, does that make you an executive officer?
Right. So the committee's setting a policy, right? The question will be ultimately who endorses that and says it's in place. So if the committee's a recommendations committee and says, look, this is what we think it should look like, but someone else makes the decision to say, yes, it's implemented or not, right? Arguably, the committee's not an officer. There's been a really interesting case, Owen, in the corporations law jurisdiction where there was a lawyer, an internal lawyer who was also the company secretary, and there was a couple of proposals being put up to the board to do something, and it's a financial services type prosecution. And that lawyer not only put the proposal up, but was really forceful in that being implemented. So he would really participated in the end decision being made. He was found to be an officer, right? But if the committee is really advisory, and all it does is puts up something and says, here's your options, here's where you could go, and don't make the actual decision, the reality is they're not officers.
But it's not been tested.
The only case we've got is that Chaffron case, but I'd be pushing back and saying, unless they're actually making decisions or sitting there at the table saying you got to implement this one, it's cheaper, blah blah blah, then you may have a problem. But otherwise, they shouldn't be officers.
I think that goes to a lot of consultancy. It's you need to make sure that the company has all the options available to it to make an informed decision.
That's right. Yep.
And the decision be clearly theirs, and hopefully for a better outcome.
Yeah.
Okay, on any more?
Yeah, got a couple more, gents. Now this one isn't specifically around due diligence or executive obligations, but it's a relevant question, I think, for this group. And it says, am I responsible for load restraint inside containers that I order from overseas?
So what we got in that, you dropped out, but am I responsible for load restraint within containers? And we have an interesting case. RMS searches a company called Futurewood, where a heavy vehicle carrying a container travelled along the Hume Highway out of Liverpool and turned into the Cumberland Highway. And you might be familiar with the very large intersection there. As the driver of the heavy vehicle rounded that particular corner, he was doing in witness statements no more than 20 kilometres an hour, which he also claimed at the time. There was a load shift within the container, and the container caused the truck to tip over. It landed on the other side, of the road, over the median strip of the divided road, and landed on top of a light vehicle with a male occupant sitting there waiting for the lights to change. That particular driver of that light vehicle was killed instantly, and as you can imagine, the injuries within that crash were quite terrible. So RMS actually intercepted 6 other vehicles with the assistance of Border Force, the Australian Customs, and none of those particular loads within the containers were restrained to an acceptable level. not to cause a load shift which would make the vehicle unstable in any shape or form. And there was a prosecution launched against the company and the directors of that company who, in the first instance, accepted no responsibility. Now, those particular, it was the type of material that was in the back of the trucks was a flat pack type arrangement of these resinous long lengths of moulded wood, for want of better words, that looked like moulded wood, made of a plastic material weighing some 20 odd tonnes. That container itself, and I was there when the container was opened, in actual fact had nothing down the sides to prevent the load from shifting in any way, shape or form. The company was investigated. Proceedings were commenced under the Heavy Vehicle National Law. This is, I'm not sure now if it was the Road Transport General Act, which in a lot of respects has a lot in terms of its construction, apart from the take reasonable steps to due diligence provisions, was very much the same as what we have at the moment, albeit much less penalty. And those directors and the company pleaded not guilty. The case was heard, and they were convicted of all those offences. So yes, the answer is, and that's whilst it's not a stated case, it was run in the local court, and those particular parties were convicted. So yes, once the vehicle is loaded on a heavy vehicle in New South Wales and travels on a road or road-related area, all the parties in the chain are responsible. And those proceedings, and this, were commenced. There's been a lot of work around load restraint within containers. There was a lot of enforcement activity that was undertaken in terms of lifting boxes off heavy vehicles and inspecting the loads within. So that's RMS having their own side lifter. You remember this? Lifting the vehicles from the heavy vehicles out of Port Botany and making inspections as to the loads within. And believe me or not, some of the loads that were within were probably crashes going somewhere to happen. Yeah, it was really quite bad.
But Owen, it comes back to what I said earlier, which is where do you fit in the chain? So if I'm a business that arranges a container of tiles to come from overseas, right, comes into quarantine, not allowed to open it till it gets to my office, what's practicable for me to do? And it comes down to then what are we asking for and who are we asking it from? So in my contract, am I saying your loads when you get them to me has to meet the load restraint guide? And I'd actually give them a copy of the load restraint guide as part of that contract and say, to fulfill your contract properly, you've got to have a load restraint guide. If I'm loading the container, that's a different issue.
Well, in that too, the investigation went along similar lines to what did you request of the loader overseas? Do you know, and simple as this, do you know what an email is? And can you attach photographs to it? Well, the answers are yes. Did you do that? Did you provide, strict instructions that need to be adhered to in terms of how the load within the container needed to be restrained or chocked against the box, the side of the box, so it couldn't move? Now, bear in mind, there's very little in terms of a load restraint fixing point in containers. They have a wooden floor, so there's various methods that can be undertaken between the particular load and the wall of the container to stop it shifting. Was any of that undertaken? No. So in the records of interview that were conducted and recorded with these directors, and there was all those things put to them in terms of what was the due diligence type steps that they took to ensure that the vehicle was not unstable when it travelled on a road in New South Wales. So in each of the answers is no. In a lot of respects, well, I didn't even know it was my responsibility. So there was a lot of work to try and ensure that there was a message that went out to people that yes, those containers are your responsibility, or the loads within are your responsibility, and it goes to, you know, steel curtains, it's still your responsibility.
And that Paul's just probably about another issue. There's also the safety element of this, the work health and safety element. So when the container gets because I had a case where we had timber again in a container in Wollongong, the guy opens the doors and the load falls on him as soon as he opens the doors, and we had a work health and safety issue partly because the system wasn't right that they were going to adopt, but also the load wasn't fixed properly. So there's actually multiple issues at play here. There's the heavy vehicle, and there's also the work health and safety.
Yeah.
What do you do if you don't know how the container's been loaded? So, you know, that's a good tip. You know, ask for a photo. Send them a load restraint guide.
Yeah, well, Graham Agnew, our load restraint expert at Zenergy, has extensive worldwide experience in load restraint and the design of load restraint methods when it's outside the general type restraint of the load restraint guide. He, being an expert and a qualified engineer, is well versed in providing advice as to how vehicles should be loaded, how containers should be loaded, and we've worked extensively with a very large international organisation who has very robust procedures for their clients, so to assist them in what is required when loading goods for their destination, be for Australia. And we've worked closely with them, and it's a really a great outcome for everybody. And it's based off the back of them opening containers themselves and the goods within that they're charged with managing it as a logistics organisation or a freight forwarder, whatever the case may be, where goods, their clients' goods end up smashed and broken. So, you know, all credit to them. And I can't mention their name at the moment, but all credit to, because I haven't asked them clearly, but all credit to them in taking that forward. Is there any more? I just note the time now. We're on over time.
Two really quick ones, so I'll get you to give short and succinct answers to these questions.
Sure.
So, first one, when contracting into another entity, would the contract manager be considered an officer for the scope of work of that contract?
Sorry, you're dropping out.
Yeah, we're dropping out, mate. Can you repeat that one?
You're dropping out.
When contracting to another entity, would the contract manager be considered an officer for the scope of that contract?
Yeah. Look, let me give you the legal answer first. I need to know more about the whole of the responsibility. My view on it, from a, you know, take my legal hat off, is the contract manager role. The contract manager could be an officer, but not likely, right? But again, what's their involvement in the total process? I think not, but you know, it depends. You need to know more about the role, but as a general rule, I'd say not.
As a regulator or former regulator, I would say yes until there's evidence to
say no.
To counter
To say
that.
no, yeah.
So the basis is you are responsible until there's you know, quite robust evidence to show that you're not. So what John's saying is
You can see I'm a defence lawyer and he was a prosecutor. You can see the difference there.
and that's the argument that's held.
Yeah.
You know, quite clearly that's the argument that's had, is the investigating official may be of an opinion based on the activity that the person is or has some duty or responsibility.
Yeah, but Owen, if I'm a contract manager, right, and I make sure all the right assurance conditions are in that contract, we're doing what we say we're going to do under the contract, we're monitoring and all that, then we're doing what we're supposed to be doing. So we won't get into that conversation.
Well, you need to be able to table that on the day.
You've got to be able to produce the evidence.
On the day. And that may be that it's offered, or equally then it may be through direction for documents and information. All right.
We've got one more, I think, Owen. You can squeeze one in.
Yeah, we'll squeeze a really quick one in. So the question is, if you fit a monitoring system into your vehicles, so for example, speed, fatigue, and mass, and you only elect to implement part of that system, but there are other systems in the background that tell you you're in breach of the law, what should you do?
You can cut out the last bit, mate.
Yeah, you cut out.
So you've got system, you're not using all of the functionality. What's the last bit of the question?
But other systems are telling you that you're breaching the law, what should you do?
Yeah, okay, let's guess what you said.
Yeah, you cut out again the last bit.
So we're saying we've got a in-vehicle telematics that monitors mass speeding and fatigue, and you don't have, let's say, the speeding element of it switched on. I would say that, and there's a scenario here is it in testing? How recent was it turned on? Let's say we go with a system that's been in there for a while, and albeit is you just don't want to know. You haven't turned it on. Well, the question be, are you exercising due diligence in terms of your control? And we're assuming you're an operator at this stage. It's about what you know or reasonably should know. And that risk assessment, or the matrix that we were talking about, is what is practicable. Should you actually have this in your business to monitor a risk, if risk has been identified as a issue for their transport activities that you're undertaking? If that can be proven and you not have those particular aspects of your business actually turned on, then I would say that you could be at risk. I've worked,
particularly if you've got nothing else that helps you address that risk.
Particularly, and I've worked with a business that actually had it turned on and was receiving the reports, and yet did nothing about it, and that's then turns into very good evidence for a regulator to use against you, and therefore there was quite a few breaches that are identified when that system was reviewed, and of course that identified risk and hazards, and therefore they were offences under the previous legislation, and I believe the company has been proceeded against, but I don't know. So I thought that the company had been was at very open risk. If that was going to the question, I know time. We will wrap it up now, and I'd like to thank everybody that's attended today and last week for that matter. And we sort of had a few issues this afternoon. We really appreciate your attendance, and please let us know if we can be of further assistance. Both John and ourselves, we're lucky here at Zenergy to have the expert assistance when our experts are probably at a point where we need that a little bit more legal understanding of some of the questions and issues. I'll ask if there are questions that we haven't gotten to or got to. John and I will have a look through those, and Owen will provide a response. So send those to Owen, and we'll get back to you. Thank you very much.
Thanks for having us.
Thank you, gentlemen. We appreciate your time, and thank you everybody for your attendance.
Thanks, Owen.